Jonathan Johnson again, Hopping Green and Sam's. I appreciate the opportunity to come back and answer some of the questions that were raised. I think I want to be very, very clear on the eminent domain language, and that is located on page 68 of your act. The act makes it very clear that the district can only exercise eminent domain authority outside of its boundaries at your direction and with an affirmative vote or resolution of this county commission. So the district cannot go outside of its boundaries and exercise that authority unless directed to and acquiesced by you specifically. There are a number of powers that are included in the special act. Chapter 120 rulemaking was discussed, fire, security. Those languages are the exact language that you find in Chapter 190 with community development districts. Those districts also have that same authority, which is why you see it here. I will give you some examples. Typically, districts go through Chapter 120 rulemaking to adopt a set of standards for how we solicit bid proposals and how we deal with protests, the appointment of a hearing officer, the conduct of the hearing. We adopt administrative rules relating to the storage of our public records and how we respond to public records requests and how much it costs to get copies, with the timeline, many of the same kind of things that you probably have in your policies and procedures. The district is absolutely, as all districts in the state, as all of the CDBs in your county, subject to the public records law. It's subject to the government sunshine law. It's subject to governmental ethics. The members of the board who are elected to serve on that board will file the financial disclosure forms required by state law. All of those things that are required of other local governments would be required of this district as well. We did spend a lot of time with your staff working through how things like fire and security services might work. The reality is the language in here allows the district to be a vehicle for financing or providing, subject to your supervision and consent, and we've got language in here that makes it very clear that to the extent, for example, that the district were going to exercise any security powers, it has to do so first through the execution of an interlocal agreement with the board, with this county. So all of those things will, as they do with CDBs, because you see that same language, will come back to this board by way of interlocal agreement to the extent that there's a desire or a proposal for the district to provide any services like that. I want to reemphasize that we are not asking you to make a growth management decision tonight. Every time a DSAP comes through, I believe you've had one, the ENCPA contemplates, and you'll see others coming through as lands are developed over time. You will make land use decisions about where affordable housing needs to go, what kind of public facilities need to be in place, the size and the density and the location of the units that can be developed. All of those things will take place in the growth management process, which stays absolutely intact and is not changed by allowing us to create a stewardship district to provide infrastructure and community governance over the lands within the NCPA and within the boundaries. Similarly, to the extent that those lands continue to be developed, we will continue to comply with all of the environmental regulations and permits. So permits have to be obtained from the Water Management District, Corps of Engineers, all of those entities, and we would continue to do so. Again, you will have those decisions, and those agencies will have to deal with those applications, regardless of whether there's a stewardship district or not. The decision, and I think the focus point we would direct you to is whether you see the lands within the ENCPA being developed with a hodgepodge of homeowner associations and community development districts in multitude, or whether we have one governmental point of contact that will provide those services and liaison with you. We think that it's absolutely clear that having one governmental body over those lands with whom you will continue to do business and who will help implement the vision that both you and the landowner have for the ENCPA is absolutely the best choice. So I think I hit those questions. If there are others, I'm happy to answer them.
Mr. Chairman, with you, Jonathan, could you address what appears to be a conflict on page 68 in paragraph G and K? In G, there's the use of the word condemnation. K is the language which restricts the ability without the consent of the Board of County Commissioners. You notice in G, there is the use of the term condemnation.
I do, and that reflects that the district has the ability to acquire property in a variety of ways. It can acquire it by donation, by purchase, or by condemnation. But then subsection K makes very clear, very specifically, that if it's going to be by condemnation and it's beyond the boundaries of the district, it has to absolutely be with your consent, which is required by either vote or a resolution of this governing board. So K tells us how we would acquire the property that's listed in G, and that's how. And again, that is language that you will see in chapter 190 for your CDDs as well.
Yes, sir, Mr. Chairman, members of the board, and members of the public, that was, K was discussed with the applicant several times, and that language was added that restricts. That's why I wanted Jonathan to address that. If you'll see the language in K, it says exercise within the district or beyond, required as approval by vote of a resolution of the governing body of the county. You have control over it. They can't go outside. Can't use the condemnation power without your specific consent by resolution. And we added that probably a month and a half ago or 2 months.
Thank you, Mr. Miller.
Yes.
Mr. Johnson, if you would, I know you've already addressed some of the questions. Yeah, Captain Mike Adams, he makes his living on the waterways and has for many years. So could you expand a little bit more on his comment about your stewardship over the marshes and the waterway?
Yes, absolutely. There is nothing about the creation of this stewardship district that will give this district or Rayonier control over the waterways that are available to the public. This is, the lands within the boundaries are the lands within the ENCPA, with the addition of some of those marshlands that Charles discussed. But this does not extend into governance, regulation of the waterways. Those remain just as they are, and there is nothing about the creation of this district that would take that authority away from any other governmental body or vest it within us.
Thank you. Do you have questions?
Mr. Chairman, Jonathan, could you explain, several questions were about the governor's role in this and the legislature's role in this. Could you explain the local bill and the legislature's involvement and ultimately the governor's ability to sign or not sign?
Yeah, absolutely. So our next step is to return here Thursday evening at 4 p.m., as you mentioned at the outset of your commission meeting. Your local delegation, this will be one of the items on their agenda. So that's the next requirement. In order to file the bill in Tallahassee to be considered by the legislature, the local delegation will have to vote to approve it. Assuming they do that, we go to Tallahassee. We will file the bill sometime by the end of February, before the start of the March legislative session. It'll get filed in the House, as all local bills do. Ultimately, it will go through a hearing process. It will be assigned to committees at the House level. It will also have to be approved by the Florida Senate. Once those two steps have occurred, then the bill will be transmitted to the governor's office, and the governor will ultimately have the ability to either veto it, let it become law without his signature, or sign it. In the last go-around, we did have some preliminary conversations, and we will continue to converse with the governor's office. We haven't asked the governor to make a preliminary and premature decision about whether he's willing to sign a piece of legislation yet. We don't think that would be appropriate, but we have been in conversation, as well as with House staff who will be analyzing the bill. So that's the process. Ultimately, we obviously hope the governor will give it very favorable consideration, but that's the process that will play out.
Like anything else?
No, sir.
Thank you very much.
One other question, maybe for, well, Mr. Johnson, more to Mike. There's been a comment made tonight, and I've heard it several times, that this act could be unconstitutional. Can anybody speak to that?
No, sir, I will first, and then Jonathan perhaps can add to that. The act was created by the legislature. The legislature created this act. There are approximately 8 stewardship districts in the state of Florida today that are valid stewardship districts operating in similar fashion. The majority of this language in the proposed special act for this stewardship district is basically statutory language that's in Florida statutes now. I have found no challenge to the constitutionality of any stewardship district, and that was created probably, correct me if I'm wrong, Jonathan, 15 to 20 years ago, the legislation was, and there's been no legal challenges.
And I would be happy to just elaborate briefly. We're very confident that the act is constitutional. You know, for example, I think there was some reference made to the provision which prohibits the state of Florida from interfering with the rights of bondholders. That's actually implementing that language. And again, I sound like a broken record. You'll see that language in Chapter 190 for CDDs. The reason it's there is that there is a provision in the Florida Constitution that prohibits the legislature from interfering with private contractual rights. So that's actually implementing that provision. One of the next steps, once let's say the governor signs the bill, we now have a stewardship district. That body will begin, they'll be elected, they'll begin meeting in public, in the sunshine, in a public venue, and beginning to conduct their business. One of the first things that a district has to do, and this is specified in the act as well, before it can issue bonds, we have to file what's called a bond validation proceeding in circuit court. So we file a lawsuit that basically sues the state of Florida and all the citizens therein to come and complain about whether the legislature has appropriately created the district, whether the projects for which we are proposing to spend bond money on are appropriate public projects, and whether we as the district have followed all the proper procedures to adopt a bond resolution and move that forward into circuit court. That results, hopefully, in a final judgment which is entered, which says that yes, this district has the authority to go issue bonds up to X amount for these specific projects. And again, you'll see that same bond validation process in any community development district, and each of them in your county has done that. The bottom line of my point is that one of the first things we have to do is to obtain judicial review of the act and of the process that was imposed. I will say of the other stewardship districts that exist in the state, all of them have successfully been validated, and the circuit courts have approved those acts and with the language that's substantially similar to what you have.
And I might add, Mr. Chairman, and part of that bond validation process, the state's attorney's office is charged to oppose bond validation. So they oppose it legally, and then you have a hearing, as Jonathan indicated, before the circuit judge. The circuit judge issues a final ruling. Same thing is applied to the other 8 stewardship districts. All of those have been validated by the court system. So that's the other check and balance. There are many legal checks and balances, and whether you approve this or not is your decision. But I just want to let you know there are many legal checks and balances. Both the legislative check and balance as is pursued or follows the legislative course, the governor. If it's approved, then you've got the bond issue, the legal challenges that are there. So there's no way that this act doesn't get scrutiny by all branches of government, including your objection or no objection letter as this proceeds. So I just want to make sure that everybody understood what's built into this entire process.
Thank you. Commissioner Edwards.
Yes, sir. Charles, this is probably directed to you because